she and I did this seminar like a long time ago, actually. What was it, 2014? And people were like stunned. We did it for a bunch of lawyers, right? How do you fit the pieces together so that you can get a kid what he needs? You have all different types of services. Sorry, I should be looking this way. Go ahead.
I sue everyone. If a child has, let's just say, autism, and they require applied behavioral analysis, we'll sue in the home and school environments. We'll sue the school, we'll sue the state, and we'll sue the insurance companies. We don't always require a lawsuit right away. We might initiate it, but we'll sue everybody, and whoever comes to the plate first wins.
Right. But at the same time, because health insurance is variable, right? Everybody knows you have to get an authorization for services, sometimes for ABA or speech or OT, or there are only so many visit limits, depending on the type of service. Both of us, even though this is what I do, health insurance, our perspective is always try to get it from the school district and fill in the blanks with health insurance, okay? Because at the end of the day, if you have an IEP, it lasts for the entire year. So, we work on a lot of residential treatment cases also for mental health. And so while Hillary is sitting in the offices doing the meetings and the IEP meetings about residential treatment, I'm working with the provider and the medical professionals to get an authorization for intensive residential treatment, right? But that's only going to go so far. Usually you're only getting an authorization for maybe 90 days, especially, and the kid really has to be severe. But that takes the pressure off of Hillary while she's working with the school district.
So sometimes, if a student is in a residential treatment facility, we can get the school district, the tuition is divided amongst three. It's education, therapeutic, and residential. So I'll get the school district to pay the educational portion. Jodi will get the insurance company to pay the mental health piece. And then the residential, sometimes we get the school district to pay for it, other times I split it. It depends on whether we're going through a hearing or a settlement. But the idea is we're going to take steps to try to get the student the services as quickly as possible. So since all of these different agencies are possibly responsible, we go after all of them, and then we try to minimize the impact for everybody. So it's not just to the students' benefit, it's to the districts or insurance providers' benefit as well.
And this is generally a revelation for the school districts. Like when I do a seminar on this, just this issue. How do you get residential treatment covered by insurance or ABA covered by insurance, and what can you do? The school district attorneys will come up to me afterwards and they're like, oh my God, really? Like, how do you get that done? That's crazy. Do you want to work for us? I'm like, no, I don't. No, you are not my people. You are not my people. But I will tell you how to do it. So looking at the list, right? Educationally based, you've got school services. Medically based, you've got health insurance. You also have Medicaid, right? Jumping down to Medicaid, kids up to 21, EPSET, they have to cover medically necessary services if a child has Medicaid, okay? And then you also have state agencies. You have adult services, you have respite, right? All these things can overlap to kind of fill in the blanks and get a child what he or she needs. Okay, so we know that Hillary just did this. So this is where I was saying to Hillary, why don't you go into some of the tools that parents can use. I was making a list. Hillary.
What's the list?
And the list was, can you understand my handwriting? No.
List. Do you have an occupational therapist in the audience?
So,
is the mic on?
There you go. So let me just tell you what my list is. So I think Hillary needs to go through, instead of going through the analysis under IDA and 504, some of those tricks that she's used, such as how do you get an out-of-district placement, right? How do you invoke stay put? How do you get an independent evaluation? Because those are tools in the toolbox that parents should have and should understand. And she went through it very, very quickly. So Hillary, you're on.
Okay. Independent evaluations. We talked about it a little bit before, but in the event that the district, if the district does their own evaluations, majority of the time the evaluations don't come with recommendations on how to remediate the challenges. So sometimes the results are accurate, the test results, but they don't come up with recommendations. Or maybe there's not an accurate assessment of the child's needs. So that's when you ask for an independent evaluation at the district's expense. And maybe the evaluation only covers articulation instead of higher order language skills. Maybe the occupational therapy evaluation only covers shoe tying and handwriting rather than sensory needs. So we ask for an independent evaluation by somebody who does not work for the district to make those recommendations.
And how do they ask for that, Hillary?
So this is good. This is like a.
How do they
So you can contact the multidisciplinary team or the director, write a letter or an email asking for an independent evaluation. I said you have to put it in writing. Okay, make the request in writing. And again, if the district says no, they can say no, but they do have to file a petition for due process against the parents in order to, if they want to reject the evaluation. If they don't do it, it's different. The timeline is different in every state. Is it 20 days in Nevada? I'm not sure the timeline in which they have to. They have to file within 30 days. Wow, that's a long time. So they have to file against the parents within 30 days to challenge the appropriateness of the evaluations they've done, or their refusal to do independent evaluations. If they don't file, then they have to do the independent evaluations.
So you can also get your health insurance to cover independent evaluations, right? So, Lori, instead of taking at face value, right, whatever the evaluations were that the district didn't do or did do, right, went and got her own evaluations. That could be very, very expensive. So in some states, Medicaid, you may be able to get, if you don't have any money, certain evaluations, and you can use those to challenge, right, what the district says or doesn't say in addition to the independent evaluation. You can also go to your health insurance company, get a speech and OT evaluation, get a psychological evaluation, neuropsych, that sort of thing. So it will cover it.
They can't deny you the ability to get your own evaluation. They can, when you give them the report, they have to consider it. And usually what you'll hear is they accept the results but not the recommendations. Okay, so that's what generally happens. The other benefit of doing it on your own is that getting an evaluation on your own is that if you do that, then you'll know whether you're nuts or not. Okay, right. Because if the district is if you're not sure if your child is making progress or they're in the right program, by getting an outside evaluator, they'll tell you you're spot on, or you know what, the district is doing the right thing, and then you'll feel more comfortable moving forward. Lori? So the question was that what do you do when the professionals in child find are not trained to do the evaluations? That's when you are justified in making a request for an independent evaluation. The other piece is that some people don't really do, but it is allowed, is that you can go get your own evaluation, and then under Section 504, you can seek reimbursement for your expert fees. Okay, so that is something that you're entitled to expert fees under Section 504, not the Individuals with Disabilities Education Act.
So the question was that the wait time could be, and it's like this everywhere, 6 months to a year, okay, for a neuropsych. So what do you do? First of all, honestly, what we do personally is we make an appointment with our developmental pediatrician every year. When you make an appointment or have an appointment with a neuropsych, make it a neuropsychologist, make it for the next year. Make the appointments, okay? Secondly, if they're, not in network, right? I don't know if you're going through your insurance and you have to wait 6 months for an appointment, that means that the insurance company is violating their network adequacy laws, okay? They have to have an adequate network in order for you to go see your doctor. So if not, then what you can ask for is an out-of-network exception, right? Which is you can use an out-of-network provider, right? Out-of-network exception because they don't have an adequate network. So you shouldn't have to wait 6 months or a year to get that. And then basically they would cover it as if it's in network, subject to the network deductible, okay? So that's a tool that we use a lot to try to get those third-party, because it's very expensive too, and it might just, put a fire under there to get that appointment for you, right? Especially when there's a mandate involved, right? So if you have an autism insurance mandate, and they're saying you have to get a comprehensive assessment, I'll get into that later, you absolutely can get coverage if there's a mandate, but you can't get an assessment that's comprehensive. So somebody was raising their hand. So what she said was, and what? Oh, no, no. So we're talking about health insurance. Two different things, right? We went from the evaluations from the school district to.
I'm sorry, one second.
Good.
There are we're talking about ways of funding an evaluation. My goal and Jodi's goal is always to try to get these evaluations covered at little or no cost to the parents. Right. Okay, and same thing with all of the services that you're going to be hearing us discuss. Our goal is to try to get the services for the kid as quickly as possible at low cost to the parents, okay, or their guardians. So one way is to go after the school district. If you go after the school district to pay for an independent evaluation, that's going to be at minimal or no cost to you unless they challenge your request successfully. Okay? Another way, because maybe you don't want to wait for the school district to pay for it, to go through the rigmarole of funding the evaluation and approving it. Another way, it's faster, is to go to a private provider yourself, pay for it, and then later you seek reimbursement under Section 504. Okay, that is another way of getting it, trying to get your money back. The third way is getting your insurance carrier to cover the evaluation. Okay, and that's what Jodi is explaining now. Does that make sense?
So I just want to repeat the question so people can hear. She said she doesn't know any evaluators that are under 6 months, right? Right now, in Nevada, in all of Nevada. Am I saying Nevada right, by the way? Is it Nevada? Nevada. Which one? We're saying it right? Nevada. Okay, got it. Nevada. Got it. It's like bagel, Nevada.
It's Nevada, right? Thank you. So what was the question? The wait time. So you can go out of state. I know it's inconvenient. I know it's really annoying. We also have that challenge in New Jersey and in Pennsylvania. There are wait lists. It depends on the type of evaluation. Sometimes you can ask, like a speech and language pathologist told me the other day, she won't do program evaluations until May. She doesn't have any time for it. But a speech and language evaluation only, she has time for next month. So it just, you might want to follow up and ask for what types of evaluations do you have available now. And I make a distinction, a program evaluation, I sometimes have experts go into the school to observe the child in their classroom to see how they're performing in the classroom setting and whether the district is implementing the approach the right way. Okay, so that's a program evaluation, and there are different timelines for that. But yes, you can go out of state. It's sometimes inconvenient, but again, it will save you time, and then you can present that evaluation to the district.
Right, and if you want to go through private insurance, and it may be that everybody in network has a 6-month wait list, right, or a year wait list, but you find an out-of-network provider, right, what you do to get an out-of-network exception is you say, you write down all the people that you called, when you called them, how long is going to take for you to get that appointment, 6 months or a year. Then you call up the insurance company and you say, I went through every single list, could not get an appointment for 6 months or a year. My kid needs, the neuropsych, it needs the ABA assessment, needs the CP, evaluation or whatever it is. And so I want to go to this doctor that I made an appointment with, either in California or someone that's private pay, but you have to pay it. And apply my in-network deductible, in-network out-of-pocket maximum. That's called an out-of-network exception. If they deny it, you can appeal it. They will have to probably, can't make any promises, but probably will cover it. But you have to go through this kind of process. We're just trying to give you kind of hints on how do you do this so you can get the kids what they need as soon as possible. Okay, so let's keep going a minute. Do you want to do really quickly, because I feel like you gave a little short shrift to it, what stay put is, because I think they kind of could use to hear that again.
Okay. Stay put is my favorite provision under the IDEA. Stay put is where the district tries to take away a service against your wishes. Okay, you think a service is necessary for the child to receive FAPE, and the district is now taking it out of the IEP or reducing the service. So I mentioned occupational therapy before. Sometimes they're changing a student's placement against your wishes. Okay, maybe your child was in one class and they're putting them in another class, and you disagree. If you file a petition for due process before that IEP goes into effect, at that point you've invoked what's called the stay put or pendency provision of the IDEA. And what that means is the district cannot change the program until the dispute is resolved. Under the theory being that at one point everybody agreed the IEP is appropriate. Now there's a question as to whether the IEP is appropriate. So we're not going to disrupt the child's program while the adults are fighting it out. We're going to keep the program as is, where everybody at one point agreed was appropriate, until the dispute can be resolved. Okay, so sometimes that goes on for a week. Sometimes the dispute goes on for, 4, 5, 6 years. But the whole time, the district has to continue paying for that service or program. Sometimes it's an out-of-district school. Sometimes it's speech and language services. Sometimes it's OT. The whole time. They can't change it without mutual consent. Yes? So the argument to have stay put go into effect under those circumstances is that under the IDEA, you have to file before the next IEP goes into effect, right? Sometimes they used to put timelines on it that you have to file in 10 days and in 15 days of receipt of the final IEP. But the federal government came out and said, no, it's before the next IEP goes into effect. Okay, so if it's a draft IEP, then there's no reason to think it's going to go into effect. So if you're having multiple meetings, there's reason to believe that that's still a draft because you're still trying to continue to work it out. Okay, if on the other hand, it's final where the district says, no, we're done, we're not making any more changes, that's when they have to give you notice that it's a intent to implement, and you have to file before that time period is up. So you can file as a parent pro se under those circumstances, and then the attorney can amend the due process petition if necessary. But they're very strict on that you have to file before the next IEP goes into effect. If you should be able to file, yes, the simple answer is yes. There's an argument there that it hasn't gotten into effect yet, so therefore you have the right to invoke stay put or pendency. Okay, if the district already made the changes, then you have another option, which nobody loves to hear, but you file for what's called either emergent relief or an expedited hearing to have a ruling on that particular issue. What is the stay put program? Okay, and it's very simple. Did you file before the IEP went into effect? If not, then they have the right to implement it. If they do, if you did, then they don't have the right to implement it. Okay.
Okay, so let's move on. All right. Wait, hold on. What do we got? We did this already? School analysis over the 504. All right, now I'm going to do the insurance piece, so you can get off now. All right. So this is just under commercial insurance. This is not, Medicaid. It's just commercial insurance. All right, if you have a commercial individual insurance plan, a small group insurance plan, and it covers services, okay? Basically, what you want to do as a parent of a kid with special needs is you want to take a look, you want to get the policy, the insurance policy. It's a contract document. It explains what your rights are and what the obligations of the insurance company are in terms of covering the services that your child needs, okay? So you want to review what does it say it covers, the insuring agreement. You want to look for ambiguities in the plan, and I'll explain that to you later. Exclusionary language, provider requirements. Does it require a BCBA, a licensed behavior analyst for ABA, a licensed speech therapist, right? Does it cover specifically social skills? If it has a broad insuring provision that says we will cover everything that is medically necessary to treat a child, and it doesn't exclude it, guess what? It's covered, okay? If it says instead we only cover these things that are listed, that's different. Only the things that are listed are covered. So you have to review the document, look at that insuring provision, see what it excludes, see whether there are any limits, see what your appeal requirements are. Make sure that you appeal and put claims in timely, okay? And you want to argue. The language is ambiguous, right? What do I mean by that? Let me think of a good example. Usually I have my partner up here, but we will only cover, speech for rehabilitative purposes only. Your kid has CP, right? They've never spoke, right? What does rehabilitation mean? Anyone know what that means? Rehabilitation means they had it and they lost it. Okay? So you try to go in and argue that they should get speech, but the policy only says, right? It says we will only cover it for rehabilitative purposes only. They deny it because the child never had speech. So you can't rehab them to get the speech. This is developmental, right? Or it's medical, or it's habilitative, right? On the other hand, the policy also says we'll cover all medically necessary services to treat CP. So you have two conflicting provisions. Which one is it? Okay? And you argue that it's a broad insuring provision. The exception is very specific to rehabilitation, but if you cover all medically necessary services for CP, you would have to cover additionally habilitative services and developmental services to treat CP. Does everyone understand what I'm saying? Right? You're playing a lawyer's game with the language, right? But that's what you need to do. Or you need to make claims within 90, let's say you forget to put your kid's speech and OT claims in. And then you put them in, they deny because they're late. You look at the policy. The policy says you need to put the claims in within 90 days unless there's a circumstances that made it unreasonable for you to put the claims in within 90 days. Well, what is unreasonable? When a kid's like screaming at you and you got to bring kids to school and you didn't have like what's unreasonable? There could be lots of arguments that it was unreasonable for you to get a claim in within 90 days, right? Especially when you have a kid with special needs, right? So you really have to look at the language because there's lots of reasons why they're not going to cover it. They're going to try not to cover it, right? And it has to be very clear if something is not covered, right? Because at the end of the day, you're the insured, and typically the policy says that it's going to cover what's medically necessary unless it's excluded, okay? You have to verify deductibles. Everybody knows this, right? Cost shares, co-payments, visit limits. Let's see what else, because I can't read. That's too big. This is too small. Exclusionary language and limitations. I have had insurance companies or payers say to me, the policy excludes ABA therapy to treat autism. So I've actually said it excludes ABA. There's a denial of ABA to treat autism, and that's why we're not going to cover ABA. Okay? And we all know the school districts, right? From what I'm hearing in Nevada, like in a lot of the country, they have like ABA light in school. And your insurance policies, right, might cover very, extensive 35-hour-a-week programs, right? Whatever's medically necessary to treat autism, right? But the insurance company says there's an exclusion for ABA in the policy. And we go and we get the policy. After you actually get the policy, look at the policy, there's no exclusion. What page are you talking about? Page 45. I go to page 45. Page 45 says something about, appeals. It has nothing to do with autism. Autism is not referenced. ABA is not on the page. So when they deny, and that's just an example in relationship to autism, but it could happen with CP. It could happen with any mental health condition. Just because they say in their denial letter, this is what the policy says, dollars to donuts, 9 times out of 10, that is not what the policy says. And if it's not in the policy, they can't deny on the basis of a provision in the insurance policy that does not exist. Okay? I mean, I've had insurance companies say there's a 60 visit limit on something when there's no limit. 10 visit limits when there's 30 visit limits. Your deductible is $20,000 when it's $10,000. Okay? So, I mean, it could be anything. We don't cover autism, right? When they only cover certain services for autism, right? Like, the language has to be clear and explicit, and it's your job as a parent or a caregiver when you're making these, requests for services and they deny them, to take a look at the plan language first. And don't just buy what they say, okay? Couple more things. Does anybody know what a self-funded versus state-regulated plan is? And I know everybody's like interested in, the SPED stuff, but this can really provide you with some much needed services. So a self-funded plan is a plan that is governed by federal law only. State insurance mandates, like the autism mandate, do not apply, right? It has to comply with ERISA and the Federal Mental Health Parity Act and the ACA. They can exclude coverage for specific conditions entirely, like autism. But what they can't do is cover some services for a condition and not others in a discriminatory manner. So I'm going to get into that in a minute, right? You have to look at your insurance card, right? If you work for one of the casinos, that's going to be a self-funded plan. All right, if you work for a big company, self-funded plan. You work for the school district, and some teachers here, there are state laws that are applicable to that, even though it's self-funded. But state law still applies, like the autism mandate. It applies to your plan in Nevada, okay? State regulated meaning it's governed by state law. It has to comply with all the requirements of state law, whether it's autism services or services for breast cancer, for hearing. There's services for hearing, typically, in most states. But they're carved out, and you have to cover, they have to cover it. No, there's no requirement that any self-funded plans, unless a provision in the plan says that they will comply with state law. If it's self-funded, they don't have to comply with state law at all, right? But if it is state regulated, they have to cover state mandated services. It's regulated by the Department of Insurance. So if you have complaints, you can go to the Department of Insurance, and you determine that by looking at the insurance card. So I wish I had a copy of an insurance card, but essentially the card will say either insured by on the back or administered by. Administered means self-funded. Insured by means it's state regulated. That's important when you have hearing, aid mandates and that sort of thing, and autism mandates like you do here in Nevada. Nevada. I'm not sure. Okay. So you also have to know if it's state regulated, because if it's self-funded, state law doesn't apply, remember? You have to know if there is a parity act. Does anybody know whether there's a mental health parity act specific to Nevada? Okay. So autism insurance mandate, everyone aware of that in Nevada? Yes, there is. There is a mandate in the state of Nevada that requires health insurance companies to cover ABA, speech, OT, PT, psychological therapy. I have the limits. It's a $72,000 limit, which, by the way, violates federal law. They can't limit it, okay? We'll talk about that in a minute. Speech therapy, statutorily mandated therapies. You have to know whether state law requires minimums and maximums, diagnoses in order to invoke coverage under state law, and the case law. Facility requirements, like a licensed behavior analyst, RBT. So the one, statute that I like to focus on, because I do a lot of this across the country with autism, is the autism insurance mandate here in Nevada. So again, you have a self-funded plan through the casinos or a big company. It's not going to have to comply with this statute. State-regulated individual, small group, it will have to comply, all right? It compels coverage for the screening, diagnosis, and treatment of autism. Treatment includes, but is not limited to, ABA, speech, PT, and OT. It requires, this is a key, guys, if you're dealing with kids with autism, it requires not just rehabilitative services, but habilitative services. What does that mean? The insurance company cannot argue that they will not cover ABA because a child is not progressing. If it is helping a child, or speech or OT, if it is helping a child maintain and not regress, under the mandate in Nevada, the insurance company has to cover that ABA, speech or OT, or other services. Okay? So you need to look at the language if you get to a point where they say, well, we're not going to authorize services because the child is not progressing. You argue under the provisions in the statute that cover habilitative services and the definition of habilitative services that they have to cover it as long as it's going to stop the child from regressing. And ABA has to be provided by a licensed behavior analyst. It applies this statute to state-regulated plans, individual, group, and government plans, but not self-funded plans, okay? Here's a kicker. I never saw this before. If you have an individual plan, you get to choose whether or not you want the ABA coverage. For all the rest of the type of plans, it is automatically implied into the plan, state-regulated plan, that the Nevada mandate applies. But if you're purchasing individual insurance under the ACA, you have to choose a plan with ABA in order to get it. So if you have a child who's kind of spectrumy, right, and you have an individual plan, but he hasn't gotten a diagnosis yet, you want to choose one of those individual plans. Here's another thing you could do. If you have a self-funded plan, let's just say, of course, this casino covers ABA and treatment for autism, the insurance policy, but let's say another casino on the Strip doesn't, okay? You can get an individual plan on the exchange that is going to have all this coverage, okay? It also has a maximum of $72,000 for ABA. Has anyone heard of anybody hitting this limit? Is anyone using this insurance mandate at all here? Does anyone know about it? Am I talking about, should I move forward? Okay, I'm gonna go quick if nobody's using it. But the teachers here, $72,000, it violates federal mental health parity. You cannot put a limit on the treatment of a mental health condition that is not applicable to substantially all medical services, okay? So that's $72,000, even though it's statutory. If you come across a situation where an insurance company is trying to limit the services to that 72, it violates federal mental health parity. And most states have gotten rid of the limits. They also can't apply speech visit limits, OT visit limits. If it's 30 visits for medical conditions, they cannot apply the visit limits to treat autism, which is a mental health condition. Even though the statute says it. Even though the statute says they can. Yep. New York too, yeah. Except for I think the limit's lower. But they can impose it, and they don't in New York. I mean, I don't know what happens here, but I know in New York and New Jersey, the limits, there's $36,000 limits on ABA, and they can't impose it. And the state departments of insurance realize that they can't. But there are states that will impose it. And I really wouldn't be surprised, based on what I'm hearing about the way things function here, that, no offense, but I had a great dinner last night, and I love it here, but yeah. $72,000 is really not actually a full day program for a kid who needs it. The whole purpose of talking about this mandate is school districts, right? They don't realize that people have commercial insurance, not necessarily the kids on Medicaid, but people have commercial insurance that will cover some of the services. Okay, and so what Hillary and I do a lot of is getting the school district in a settlement, right, to agree to cover anything that health insurance won't cover. Deductibles, right? Premiums, sometimes co-insurance, co-pays. That same, so what Hillary just said, because I'm afraid I don't know if the cameras got me or don't got me or whatever, but point is that it doesn't have to be ABA. It could be residential treatment. It could be speech and OT and PT. It could be, psychological therapy. What we're talking about is, if a parent has private commercial health insurance and it does cover some of these services, what we try to do is figure out, generally speaking, what the plan covers, try to get the claims going, right? And then, Hillary's going in there and negotiating with the insurance with the school district and saying to them, look, we've accessed these services. You're lucky that we get insurance to pick up a portion of this. You agree that you have this obligation under the IDEA. You're going to provide it during school. Maybe you're going to provide it after school if insurance doesn't cover it, because insurance is variable, right? And by the way, if residential treatment is covered for the next 3 months, you're going to pay the parents $10,000 deductible, right? And their co-pays or their co-insurance.
So wonderful. So the question was, or the comment was, that the school district said that they are capped at the amount of time that an RBT can spend in the school district, or in this particular class. The response that I would give is, please show me the law that says that. So because there is no law that says that, by the way. So that's the. Okay, so again, show me the policy, show me the law that says that. Because what I can say is, during COVID, I think BCBAs and RBTs have been phenomenal. RBTs, by the way, are registered behavioral technicians, so they're trained in ABA at a higher level than a paraprofessional. So they're trained in ABA. They're not board certified behavioral analysts, but they can help implement the ABA program. They have to be overseen by a BCBA, though. So they're collecting data, they're implementing programs, but there is no law on how often or how much the RBT can be in the classroom. So if that's the response, then if that's a comment, then just go back, please show me the law, and then we'll discuss it.
Right. Or sometimes they do have written policies against having third parties come into a school district, whether they're through private health insurance or not. Are you talking about someone that's a private, like health insurance paid RBT through a clinic, or, right? They're Medicaid. So, right.
Okay, so that's their choice to get Medicaid funding, right? For this, but it doesn't. The IDEA doesn't say that. So if they're going to choose to get that, that's fine. But they have to still ensure that the student is receiving FAPE. Okay, and if not, then they have an obligation to supplement what they're paying, what Medicaid is covering through that.
So let's talk about Medicaid a little bit, actually, because I think people are probably really interested in Medicaid and EPSDT. So apparently there are a lot of people that are accessing services, including ABA, through Medicaid, correct? That's right, in Nevada? Okay. And we heard the other day that the school districts are charging for non-licensed RBT services, non-licensed BCBA services like ABA Light to Medicaid. They are, for sure. Okay. So that's not okay. So if the provider, there was an ABA provider that was sitting in the back of the room right behind me before, if they tried to get Medicaid to cover services by non-licensed provider, it would violate Medicaid law. And even if Medicaid paid it, guess what? If the provider got reimbursed, Medicaid would then have a right to get, the money back because it was rendered and, provided by a non-licensed provider. Okay? So what the school districts are doing here, if they are charging for ABA Light by non-licensed providers, even if the school district allows non-licensed RBTs to provide services, that doesn't mean that they can charge Medicaid. That is a whole different layer of statutes, right, that require medical necessity, that require licensed providers.
Sorry to interrupt for this breaking announcement, but the school district cannot provide ABA by a non-licensed provider. No, there's not a law that supports that. Okay, it's not ABA if they're not licensed, right? It's a nuance, but it's not ABA if it's not being overseen by a BCBA, okay, because the law requires that. It's not ABA if they're not collecting data. If none of this is happening, then they're violating not just the Medicaid laws, but they're also violating the IDEA, Section 504, and every other law that exists. Thank you.
So on the planet. So I think what to state it another way, what Hillary's saying is they shouldn't fucking do it. Okay? But they do, and they're going to try to do it. Can you guys bleep that, please, for me? Sorry, I have to do it every time I talk. All right. But they should not do it. All right. But I think another way to put what Hillary's saying is like, it's not that they're providing ABA through non-licensed provider. It's that the school districts are not providing ABA, right? They may be able to have people work with kids who are not RBTs that are licensed or BCBAs, but unless you have a program being provided and it's ABA, pursuant to, goals and objectives and programs and BIPs provided by an RBT that is licensed here, supervised appropriately either 1 to 10 or 1 to 20 hours by a licensed behavior analyst where they're taking data and graphing. It is not ABA, so therefore...
It's an eclectic program.
And it's not ABA. It's just not ABA. Okay?
And by analogy, it's the same thing as though a student with dyslexia is getting they're claiming that the teachers are providing a structured literacy intervention through a 2-day training. They're not trained in it. It's guaranteed that they're not doing it. Okay, if they're not delivering it with fidelity, they're not doing it. It's not ABA. There's not a law that supports it. Okay, thank you.
Thank you very much. Go ahead. We got a question over here. Okay, so she's asking whether or not you have to check off that they can bill Medicaid. The answer is no, you do not have to check off. They can bill Medicaid, but they can't bill Medicaid for services that aren't mental health or medical services. Okay? So, right, meaning it's covered by Medicaid, right? It cannot be just like we decide to charge Medicaid for what we think might be the services that they might cover, right? You as a parent under the Medicaid rules do not have an obligation to check that box. You can get those Medicaid services from an outside provider. You do not have an obligation to assign your rights to provide Medicaid services to a school district. In fact, when you look at the regs, the Medicaid providers can come into the school, actually. They can come into school, provide the services. Do not have to take those school services or let them charge for those services under Medicaid. The box is so that they can charge, basically they can be reimbursed if they provide Medicaid covered services, but you don't have to check the box. And it doesn't disabuse them of their obligation to cover the services under the IDEA or Section 504. So for my purposes, I hate to say this, but I would much prefer you didn't check the box, right? And then if you have to bring in an RBT, right, then it's under Medicaid. They don't get to say that RBT isn't licensed or that BCB isn't licensed. You're bringing in like an actual service provider that has the appropriate credentials and is providing the appropriate level of medical and mental health services. I mean,
that's all.
What she said was she had a situation where she was unhappy with the services that the state, that the school district was charging to Medicaid, and because she checked the box, she couldn't retract it. No, I think ultimately you probably could challenge that and retract it, but at the end of the day...
You can challenge it because still they have an obligation under the IDEA. With the ramifications to the school district, they might have to pay Medicaid back. That's a different conversation. But you, as a parent, are not waiving your rights under the IDEA if you check the box. Okay? So under that said also, if you do check the box, like I said, you're not waiving that. Okay, sometimes it does reduce the cost to the district. Okay, and the downside is what you're being told, but not actually what's in effect. Okay.
Great. So if you have a private ABA therapist that's covered under Medicaid and they're going to actually have licensed providers pursuant to a treatment plan and do 6-month authorizations and sit down with you and show you actual progress as compared to a school district that has ABA light with non-licensed providers that doesn't take data and has a BCBA come in once a year, what do you want? Why would you check the box, right? Do not check the box. None of those do not check the box. Unless you are we can maybe use that in the context of a settlement, you know what I mean? If they actually have the nurse or the ABA provider there, it may be used to pressure them then to start to hire people so you don't go outside, of the school.
And I just thought of another example of not checking the box. So if you leave here with nothing else today, just don't check the box, right? But if there are times where you might be eligible for certain services under Medicaid outside of the school, right? And you're getting that, if you check the box, you're getting those services, Medicaid's covering it, right? So then it might reduce your chances or your access to the services later or in a different context because they're getting it already through the school district.
Yeah, you want everyone to carry the burden, right? You want Medicaid, if you've got Medicaid, to carry the burden of what it's supposed to cover. You want the school districts, we kind of call them like buckets, right? We're talking about 3 separate buckets. You've got the IDEA 504 school obligation. That stands alone, regardless of what Medicaid does or private health insurance does.
Or
That,
state agencies.
right.
If they use a state agent, if the district uses a state agency to provide a service, they can do that because they have an obligation to reach out to other services, support agencies who can provide it. But if you're not happy, or if the quality of services doesn't result in meaningful progress to the student, you still have, the district isn't off the hook. They still have an obligation to either make up the services through compensatory education or change the services to ensure the child is still receiving FAPE.
So you've got your special education bucket, Medicaid bucket, right? Might be respite in there. There might be more ABA in there. There might be speech and OT, et cetera, psychological services. Then you got your, if you're lucky enough, maybe you have health insurance, right? The goal is to try to tap into and cause each separate, what I'm going to call payer, to carry their burden. Don't let the school district offset their obligations onto Medicaid or onto the private health insurance carrier. Once you get it in an IEP or a 504 plan, they're obligated to provide you with those services for 12 months. Medicaid, up and down. Maybe you can get a provider, maybe you can't. You know what I mean? Maybe you can. But what if it goes away? What if the authorization isn't issued, right? Maybe there's a wait list. Well, you can't be, but they still might. I mean, what right. Hillary, come on.
Hi, how are you?
No, we want you to call the parent, right? We want you. We want you to call that parent. I had a great teacher in my kid's school, and afterwards, after meetings, like how much of that is because he's a boy, right? We had, we don't do speech 4 times a week. We do it twice a week. We had all that. Well, I'm a lawyer, right? I didn't know Hillary at this point in time, right? But anyway, this, great. First she was a teacher, then she became the special ed person, et cetera, et cetera. She would whisper in my ear, you need this, you need that, you have to ask for this. That's a fabulous thing to do. But we can't, and there's a law that protects you under 504. You can't retaliate. At the same time, school districts might retaliate. I hate to say it.
So they might retaliate. So here are a few different things to think about. Okay, and I'm not going to tell you what to do. So I've had several situations, including in Nevada. The Rogish family is not the only case that I've had here, but where the districts, the teachers might privately text or send a message separately saying, "Ask for this." Okay, that's one thing that has been helpful. In cases where teachers do that, we're suing and going to a due process proceeding, the parents will let me know that, and then I might go lighter on that teacher. Okay, so there's that piece. But separately under Section 504 on a legal level, because we're going to pretend to be lawyers for the sake of this afternoon, if you are protected under 504 as teachers. So if a district does retaliate against you, I'm not saying you should always jump to a lawsuit or you have any desire to jump to a lawsuit, but you can use a teachers union to argue, or if you want to do it on your own, there are employment lawyers that most employment lawyers take things on a contingency. Because that's the type of case that it is. So if they take it on a contingency, that means you're not going to have to incur the legal expenses. The attorney will do it on their own until they.
So I always try to look at things very practically. We, as teachers or special ed, folks working in the school district, right? You might be sitting in meetings, you might be the special ed consultant, you might be the occupational therapist, you might be the teacher, right? I think it's really best to say how you feel in the meeting and speak your truth in terms of what you think is happening, because that's your obligation, whether it's occupational therapy, speech, your special ed, your general ed. You're in that meeting to talk about what the kid needs and what's going on in the classroom. You should, to the extent that you can, you should be saying what you need to say on the record, right? You're like the conduit. You're the light. Dan said it before, I think. Like, you're that sun, right, that needs to be there in that meeting. You probably have a statutory obligation to say, right? You do, right?
You do.
You do. And ethical. And if more teachers like stand up, right, and you don't have to do it in an aggressive way, and you don't have to do it in a way that you're beating up the district. Well, this is what I saw Joey do, and this is what I see repeatedly Joey doing. And, I was looking at X and wondering whether this type of service will work for Joey, or here are some of the things that we do to make Joey's behaviors whatever. You know what I'm saying? If you do that in the meeting, get it on the record, open the dialogue up, it's going to be a lot more effective, I think, for families and open the eyes of the school district. And, frankly, if it's on the record and then they retaliate against you, they got a big problem on their hands, right? As opposed to having a conversation, on the side, right? Right. So no, she's talking about, I just want to say it for the Nevada PAC, which are advocates. PAC, right? PEP? PEP. The other thing is if you're going to whisper in a parent's ear, don't do it in writing. I mean, I hate to tell you, but you don't want to create a paper trail. Like, if you really have to, don't create the paper trail. But we would love it, I think, if we could start to do teacher trainings here in Nevada about more in depth on what the law is, and kind of give you guys the tools, because it sounds like there's a lot of people in this room that want to be able to speak up. So, and help them learn how to speak up and how to ensure that the school districts are actually doing what they need to do in these IEP meetings. Okay, so, Dan's doing some good stuff, but, right, they're all worried, and so we need to kind of maybe educate some teachers and maybe get the unions behind, making sure. What? What also will help the teachers to memorialize the behaviors, okay? Right? I mean, my recollection is when my son was little, they had the notebooks and you have the memos and the emails or whatever. Stuff happens with a kid in the classroom, or they miss OT or whatever it is. You're doing your job just simply memorializing this stuff in writing. And then I heard somebody ask before whether or not you had a right to data, and there was a conversation going on in front of us, right? You have a right to your kids' educational records. Families do. And not just a separate report, but all the educational records. So to me, if the teachers, and I'm sure can memorialize what's going on, what their recommendations are, what the behaviors are, you know what I'm saying? Build the record for the families. You're doing it without doing it. You don't have to say it. Right?
You can email a supervisor asking for help, asking for suggestions. No. Hold on. I'm not saying that you should be expecting a response. Okay? But you're documenting, you're memorializing that this is a behavior, I don't know how to address it. Do you have help? And then if the parent happens to get a hold of the student records, it will be in there because it's considered a student record if you mention the child's name in the email.
Or document the emails to the parents. Today I saw Joey do this. Today I saw Joey do this. Today I saw Joey do it again. Today, you build enough of a record, the school district is not going to be able to ignore it, right? Eventually, mom is going to walk into the IEP meeting and be like, I got 15, 30, 50 emails about Joey, running around the classroom.
Okay, this is being recorded.
Oh, sorry. I didn't curse again, did I? Beep that again.
He's going to fail regardless under that model. So, there are so many bigger issues with that. So, if they don't... They cannot go past 10 days. They can't with a 504, but because that's exclusion, that's discrimination. You're denying them access to their education, right? But then, so that's under 504, but also under the IDEA. Even if they have a 504 plan, then you're questioning why hasn't that child been referred to Child Find for an IEP if they've been denied access to their education for that period of time? Okay, and then under the IDEA, they also can't be denied access. Their placement can't be changed or they're removed from their education for more than 10 days without a manifestation determination. Their placement due to extreme behaviors can be changed up to 45 days to an interim educational setting, okay, alternative educational setting. But I have so many concerns about that, because now, I mean, aside from, I can go into this, but you guys, are you okay staying a little bit later? Okay, so, I'm sorry, are you okay with this? I'm okay. So, one, we appreciate that. So one, let's just say, so I talked about before, if a child is engaging in a behavior that results in being home, they're happy with that, they're going to continue engaging in that behavior. If at some point you put that behavior on what's called extinction, for lack of a better term, meaning you're trying to you're trying to stop the behavior, then you have another question. They're going to start teaching themselves, because they're smart, another way of getting to that, getting to that outcome, right? So they're going to start learning and teaching themselves how to do that. Okay, so that's a problem, because the behaviors could get worse as a result of that. Why are we not doing functional assessment? So there's an FBA, which is where you collect antecedent data, behavior, and the ABC data. You collect data on the antecedents, behavior, and consequence. What happens right before the behavior occurred? What is the behavior, and what is the consequence? So for my brother, for example, he jumps up and down. Okay, what is the antecedent? I probably said no to something. The behavior, he jumps up and down. The consequence is I give in, because I can't stand him jumping up and down anymore, right? So now he's learning that by jumping up and down, he gets what he wants. So instead, the behavior plan is I ignore that behavior, and then he has to teach himself another behavior to get what he wants. So he'll say, so now I'm ignoring it, and he'll go, hi, Hillary, I want iPad, and then I'll give him the iPad to reinforce the positive behavior. Okay, so that's a functional behavior assessment. You shouldn't have to, but you can ask for it. You shouldn't have to, but you can ask for it. But what I can't figure out for the life of me is that the next thing is, if you can't understand the function through an FBA, they then do a functional assessment, which is setting up the environment to trigger the behavior to test a theory or hypothesis on why the child is engaging in that behavior. Why are we only focusing on the negative? Why are we not doing functional assessments to identify what makes the child happy? Okay, because they're going to learn in a better environment. They're going to learn faster if they're happy, right? So why are we not doing assessments to figure out the best environment for the child to learn, rather than what circumstances that triggered the behavior? I'm sorry? I have no doubt. Okay, but there are behaviorists who come around the country, such as Greg Hanley, or people who have been trained by Greg Hanley, who...
There's some ABA therapists right behind me that do this.
Okay, yeah. Right? So I don't know. I don't know what people are trained in, but it's called the practical functional assessment. Why? So if the teachers are burnt out, or they're not trained in it, because it's quite possible, not intentionally. I'm not saying there's anything wrong with it, but they're just not trained in this, because that's not what you went to school for. There are people out in other areas that will come in to do that. There's a Facebook group on this type of approach. Where I've tried to get providers, I go onto this Facebook group and I reach out and I ask, is there anyone in this area that can do this type of an assessment? Okay, so that is something that we're setting up the environment for them to be happy. Okay, and then they can learn. Do you need a cough drop?
No. Oh yeah. That would
yes. So they have to, but it's called FERPA, right? Under FERPA, but I've done OPRA, Open Public Records Act, is the same thing here. Open Public Records Act requests, where I request all, and this is for public records, all emails that have been exchanged with these initials. Okay, so if it's not part of the student file, then I'll do an OPRA request and ask for that information, because I have to hand it over. And that's another way of getting other information. I had a case a few years ago where I was convinced there was a same-sex couple, and they had 3 kids who had been classified. Okay, the director came in, declassified one of the kids who had autism, or proposed declassification. We challenged that. We went to a hearing. We won. Okay, but then this happened again with the other kid. And within 5 years, the district proposed declassifying all 3 kids and made us go to a hearing twice for the same kid. Okay, so the first hearing, I was like, okay, I think something is off here. It's not just about special education. This is personal, but I don't know how I'm going to prove it. Then it happened again, and then it happened again. And I did an Oprah request, and I found an email exchange where the director was saying to the psychologist, gotcha. Okay, and I used that in a hearing, and we proved retaliation. It was like a code red moment for me, in A Few Good Men or in Legally Blonde, where she proved that it was the perm that, this is important information that you thought you'd get here. And so it was like a code red moment for me, where I was like, I proved, she admitted on the stand, because she had no way around it, that she was retaliating against this family. Okay, and I didn't know if it was because they were same sex. I didn't know if they were difficult parents. I didn't know, but I knew something was off. So I was going in all avenues, and I got that information because they didn't put it in the student records, but I did get it in another way. You can go for as long. You can go forever, but they do try to say it's too vague or too ambiguous. So I would be the more specific you can, the better. I mean, one time our initial request was very broad. So they said denied it based on that.
Nothing. I'm like, wait, no, God.
You gave me the mic.
Yeah.
So they came back and they said it was too broad, be more specific. So we sent them a 4-page Oprah request, single space, from email from this person to this person on this date, with this date range, in 4 pages. They've never told us our requests were too broad again. So here you go.
So there's somewhere
So yeah, in the context of just litigation too, like if you get into a civil litigation, every email that mentions the kid that's an issue would be eventually at some point or another potentially producible. Okay? Any email, any document. But the first place you start is with FERPA. FERPA. You want to look at FERPA because the book you were talking about, the notebook with your kids' data, you have a right to that. They have, and I think there is isn't there a penalty if they don't? There's a statutory monetary penalty if you ask for it in writing and they don't give it to you within a certain period of time. You have a right to all of your children's records, and the term record, educational record, is defined by the statute. So you have a right to that notebook. Maybe they have to redact those other kids' names, right? But you have a right to the notebook. You have a right to the emails and the communications between the teachers and the administrators and the IEP team. That's all part of your kids' FERPA educational records. Tell them what you want the notebook, and you want them to redact it, and it's part of your kids' educational records. And here's FERPA, and here's what FERPA says, and if you don't give it to me, guess what? You're going to pay me the money. Right? I'm going to hire a lawyer, and the lawyer's going to go after you, and they're going to get not only whatever that amount of money is per day that you get charged because you didn't produce the records, but probably your attorney's fees. We got to train lawyers here in this state, right? You got to be aggressive and kick some butt. Okay. So she wants to know how is it going to help the other parents? Okay.
Okay. So there are 2 different ways of answering this. One is that the district could continue to just say, no, you're not entitled to it. You have the right to challenge it. There's a basis to challenge it. Okay, this is the first case in the country where it said that it's discrimination not to include a structured literacy approach under 504. Okay, in the IEP when a child needs it. Okay, so from that perspective, you have case law. The district will likely not say no to that again. I'm not going to guarantee it, but if they do, you have the right to challenge it. So districts any district can do anything, and then they can do anything until you challenge them on it. They can say anything unless you challenge them on it. So when I started this presentation at some point today, I had talked about we're trying to make parents more aware of their rights. Okay, through the PowerPoint, I included some red flags so you could say something's off here. I want to challenge that. ask questions. Okay, do more parent trainings. We will do more parent trainings, either over Zoom or in person. Okay, and make it be aware and talk to people, talk to other families, challenge it because they don't get it. So, and then file for due process. Okay, and you have case law on your side for that. Okay, so districts are, my understanding from people in this room is that since the Rogish case, the districts have been training more teachers in their methodologies. I will say, I don't know if it's a 2-day training or an actual certification, but they're starting that process, okay? And then we will challenge the appropriateness of the programs if they're not doing it right, or if they didn't get the requisite training. We will continue to challenge them. We're not done because of the Rogish case. That was a starting point.
Right. And teachers, right, educators in the room, special educators in the room, occupational therapists that work with the school district, paper the file, communicate with the parents, give the parents the leverage that they need and the evidence that they need to show either that the district is serving the kids appropriately or is not, right? Because if you're, I hate to say, but you're complicit if you don't, and you're not going to change things unless you record what's going on and kind of be an aid to the parents. And then we need advocates. Like, who's the lady that was here that you're in Arizona now? You're not allowed to stop helping families in Nevada. Okay, you're retired. You can do things. It's good, right? Providers, we need your help so that if a kid is not getting what they need in district, right, maybe we can work with you so you can give them what they need, and then we can go after the school district and get you reimbursed, right, and get the families reimbursed, right? There's ways that we all need to work together to try to change things. Is there a statute of limitations? That's a good question.
There's a 2 to 4 year statute of limitations to raise and challenge the school district. So it's 2 to 4. I say 2 to 4 years because there's an ambiguous case that says that the initial statute of limitations is 2 years from the date you knew or should have known of the alleged violation. Okay, but then there's another case that says that when did you know of the violation, and it just happens to extend it for another 2 years. So the simple answer is I would file within 2 years. Okay.
You know, the other thing that we can do is make sure that there are parents that are, like, have kids with special needs that are serving in local school boards, that are getting involved in the school, because that's how we change things at my family school, my son's school. We got there, they didn't do OT more than twice a week or speech more than twice a week. And, you know, we got involved with the school board. We got involved and made sure we made them very aware about their special education obligations, and things really changed. So there is something to be said, if you can, if you're a parent, with, you know, getting on the inside too. I mean, we've got to kind of approach this thing from all different directions. You're just in it. You're in it. Are there better schools than, because I asked this question in a meeting yesterday, are there better schools, like, not private, I'm talking about public schools. Are there better public schools? That's it. It's just.
Okay, so. Yeah, no, it's it's the 5th largest school district in the country.
Yeah, but that are better with the sped stuff. We've devolved.
Okay. So, okay, hold on. I'm sorry.
All right.
We're not going to claim that this is going to be an overnight fix.
Right.
Okay. It takes there's a process. I will say there are not enough attorneys in this area that practice. I will say there are national organizations such as COPA, okay, COPAA, that does do trainings, and I'm part of it. We do trainings for advocates and attorneys to get involved in this field. Okay, where it's a national organization, and we go from East Coast to West Coast, all of our conferences. This year it happens to be in Boston in March. but we do lots of trainings, okay? There are not enough people challenging the system. I'm not faulting. I'm sure a ton of people are burnt out and they don't think it's going to go anywhere. I understand that by suing the district for 150 compensatory education hours is not going to get you that far if you don't like the services that the children are receiving anyway. So you don't want more of the same. I get all of that, okay? But we are working. I have a case right now against the Clark County School District where we will be bringing in a BCBA from New Jersey to come and evaluate the ABA program that's in the district, okay? And talk about evaluate whether it is or not really ABA, okay? We are making movements, but we also need your help. Okay, so I'm not an expert in every nuance of the Clark County School District. I'm not I'm not an expert in any nuance of any school district. But what I can tell you is that some people think I'm an expert in the law. Okay, I've been practicing in this area for 16 years, like I said, solely in this area, right? So I have some experience in this. All right, so what we can say is the law, in spite of several IEP meetings that I participated in where I was told what the law is in Nevada, I can tell you that it is federal law. Okay, so we need to, I'm trying to try to get your help and passion. If you have a family member with special needs, or if you are a teacher, though you're invested. Okay, so you are the best people to be challenging the system. Okay, I'm invested. I have a family member with autism, and I have a nephew with Tourette's. Okay, you are the people, we are the people that can challenge the system to make it better. Okay, we are working with the Legal Aid Society Foundation. Center. I was close. The center. To make changes, okay? But again, they are overwhelmed as well. So they are willing to do trainings. I'm willing to do trainings. We're willing to oversee the process as you navigate it, okay? But we do need your help because there are not enough people to do it, okay? So we will work. We will make changes. It has to start somewhere. The Rogish case, when we started, okay, was all to help everybody else. It wasn't really to help their daughter. Okay, we got involved from the well, it was to help their daughter. It became
helping everybody else.
What did I say?
She kind of said that. But she talks really fast, so it's really hard to tell.
I have no idea what I said by this point, so I apologize. It was right. So, I mean, we talked about the issues. We talked about how things were evolving. And as we're moving forward, Lori was getting more emails and communications from other parents, and it became very apparent that they weren't alone. It is a systemic problem. We're aware of it. But they could have stopped early. They didn't. Okay? We pursued claims that we didn't have to pursue intentionally to make changes in the district. Okay, so it's a starting point. We are going to continue as long as the parents want to challenge it, as long as the teachers want to challenge it. We want to get the teachers more training. Okay, we really do. There are ways of doing it. We have tons of ideas based on just our experiences from around the country. Okay, we want to make it happen, but again, we need your help. Okay, so I hope you, with that said, we are going to wrap up. I hope you learned something today. We're back here tomorrow. Okay, we're going to be talking about similar things, and you might hear new information. If you're tired and you don't want to hear any more, I get it. But we are back here.
Flipping or staying the same? Okay, got it.
Okay, so it's going to be the same sequence as it was today.
But what I do is going to be completely different because we just winged this. Right?
What Jodi's going to do is completely different. But again, tomorrow we're going to be talking about things. Feel free to come back, and hopefully you learn something, and we'll continue taking it forward. So thank you again.